Thank you. Thank you, Sherry. Appreciate that. And what an exciting time. Thank you so much. We have 137 people here. We had a lot of people register. We are going to record this. So those that can't join are going to get a recording of this. Shout out to NCJ, FCJ. They're 88 years old. So they've been around for a long time, doing great work. She did mention the website, and I do want to tell you really quick before we get going. What is an ICWA court? You might ask that question. Like, yeah, what is an ICWA court and how did this all come about? So this is the NCJ FCJ website. So if you type in ICWA Courts, this is the first thing that's going to come up on Google usually. I think it is. And so, but if you type in NCJ FCJ ICWA Courts, it definitely will be the first thing. But an ICWA Court fundamentally is 5 things. How these 5 principles came about is in 2017, there was only 5 ICWA Courts in the country. We got them all together. We brought them here to Denver, where I'm calling in from today. And we had them sit at round tables, and judges sat with judges, and we had them, hey, what are you guys doing? What are you guys doing? That's all the same. Tribes were there. County attorneys were there, parents defense, children's attorneys, social workers. We had a big group of people there, and 4 things came out that said, we're all doing these 4 things. And it was judicial leadership. You have a judge that's willing to lead and preside over the bench and also do some off the bench kind of stuff. Data collection, which we're going to talk about today, and we're going to talk about some of that early data. And we're going to turn that over to Alicia here just in a second. Training, so everybody has just a basic knowledge of the law and understands the spirit of the law. I'll have to admit, some of this stuff was aspirational at the time. Like, we need an ICWA training so everybody knows the law. So some of the people didn't have it at that point, but that's what they wanted to have. And number 4 was tribal stakeholder collaboration, that they're willing to listen to tribes, they're willing to correct. And I would even expand that today is great ICWA courts listen to lived experience. And so I think they take advice, and that is a data point that moves practice. It's a human data point that moves practice. And then a little bit later, the 5th principle came along, which is gold standard practice. And we want ICWA courts to do something different. And so that's how those 5 principles came to a 4. There is a brief by Casey Family Programs that just recently came out, and I'm going to throw it in the chat for you here just in a second. But I'm really excited to talk to you about ICWA courts today. What we're going to do is we're going to have Dr. Alicia Summers talk to us about 2 sites that she researched last year and kind of give us the framework of some of that data and the research that came out of that. And then I have 2 of my friends that are going to join us for a conversation. Judge Janet Bostwick from the Pima ICWA Court, and Shana King, ICWA champion and parent advocate up at the Indian ICWA Law Center, Minnesota ICWA Law Center in Minneapolis, Minnesota. So we're gonna have a conversation and hopefully have a really expansive conversation. And if you have questions, I'll be looking in the chat the whole time, but I do have some questions prepared for them. And so hopefully we'll really expand with this idea about capturing data and how do we use data in informed practice and really kind of dig deep on that. But if I'm not asking the right type of questions, throw it in the chat for me, please. But while we get going, I see people are using the chat right now. I'm going to turn it over to Dr. Summers. But tell me if you've been in an ICWA court. So I know everybody's doing introductions right now. So you could even type in there, yes, I've practiced in an ICWA court, or yes, I've been in an ICWA court in your introductions as well. So I'm going to turn it over to Dr. Summers right now. Thank you.
Thank you. Good morning or afternoon, everyone. I'm excited to be here today and talk to you a little bit about data and the ICWA courts. We've done some really fun work in the last year or so trying to really look at ICWA courts, and I'm going to give you an overview of some of the methodology and research findings that we had just for 2 sites. There's additional evaluation work out there that's ongoing for even more ICWA courts. We're just going to focus on a couple today to give you a little teaser of what's happening, since not all of this has been publicly released yet. So with the ICWA courts, just at the high level, there's 25, I believe, and Sheldon can correct me if I'm wrong, at present nationally. Sheldon, were you going to?
24.
24. There's 24 at present. And these are not tribal courts, that are state courts with enhanced ICWA practices. And that means a lot of different things. And we're working with the courts to better understand what being an ICWA court means and what they've done. Some of these courts have been around for I think close to 2 decades. And some of them are much more recent or even just starting in the last year or so. But despite this fact, we have very limited research on the effectiveness of ICWA courts at meeting their goals or at improving outcomes. I will say, though, there is some research out there. It's been published in both reports and in journal articles. We have research on Duluth, who has been in ICWA court for somewhere around 10 years. And there's research out there that does show that pre and post development of their ICWA court, they saw significant changes in practice and better outcomes for children and families. And so if you're interested in what's available and what's out there, we at least have one site where there's research out there that's been published and several different studies done around it. But other than that, we don't know a whole lot about the ICWA courts. We have good theory about them being effective, but we haven't really dug in and looked at all the data to see how effective they are. So this study was an opportunity for us to really start learning a little bit more about the ICWA courts. And so our purpose for the study was twofold. We wanted to know, does practice change after becoming an ICWA court? And we worked with 2 sites, and the sites were very different. One had been an ICWA court for a long time. You can imagine if you've been in ICWA court for more than 10 years, it's going to be really hard to do a pre-post because a lot of things have happened in the last 10 years that are going to impact practice, state laws, federal laws, their trainings, policy, all kinds of stuff has happened. So you can't just say, in the year 2000, did they look different than the year 2020? It's going to look really different. And so when it was in a reasonable amount of time, we looked at pre and post. What did cases look like before there was an ICWA court, and what did cases look like after? If they'd been in ICWA court a long time, we talked to them about any additional changes that they had made or things to be more responsive to the community. And then we looked at a period of time. And we wanted to know, how does practice change? And then as a bigger picture, we wanted to know, how does ICWA practice relate to outcomes for children and families? Something we've looked at before out of the context of ICWA court, but we'd like more data on. So that was the purposes of our study. For methods, we did a structured file review. Now, that's gonna be limiting just because we're only looking at the paper files in the court. The benefit of this is we can follow a case from open to closure, and it gives us data throughout the life of the case. There's lots of limitations, and I'll talk about some of those later with doing this methodology, but it lets us look at the case start to finish and compare those cases over time. For one of our sites, it was a really clean pre-post before and after ICWA implementation, and the other we looked at cases that opened in 4 years in a row to see how the practice may have changed as they implemented additional things into practice. And then for this particular study, we looked at a couple things, talked about the letter and the spirit of the law. We looked at the letter of the law stuff for sure. Did they have a qualified expert witness? Did they make the appropriate findings on the record in the timeframes they were supposed to? Was notice provided timely? All the things that they're required to do that are kind of like check, 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 this happened, and this happened when it was supposed to. We did look at those. Those are easy to find in files. We also looked at the tribal involvement in the cases. Presence of the tribe at hearings is easy to find typically because it's documented in a court record, but we also tried to go beyond that and look at participation or involvement of the tribe in things like case planning or in assessments or making placement recommendations. We tried to look at some of those to expand the involvement of the tribe, as well as look at how the child might be involved in tribal or cultural activities, if we could find that data. And of course, we looked at outcomes. So not only where the child is placed across the life of the case, but the ultimate permanency outcome. Where did they end up? Did they end up back with family? Back with parents, or was there a termination of parental rights and adoption to strangers? So I'm going to jump right into what did we learn, and I'm going to do the sites individually because no big shocker here. The data looked different across the different sites. So we'll start with the one that was the clean pre-post. And there's a little 1 in the bottom, so you can see this is site 1. What did we learn? Well, one of the things that we learned was in our ICWA pre-post, after implementation of an ICWA court in this site, we saw a statistically significant change in the ICWA legal practices. In particular, these two areas in the red boxes, you can see there's a pre is the green and the post is the orange. There was a significant increase after they became an ICWA court, making the findings on the record, using the clear and convincing evidence standard, making sure it was active efforts instead of reasonable efforts finding, and having a notice of petition filing with a return receipt documented in the file. That does not mean that there wasn't notice. There was evidence of notice in a lot of the files, but we were looking for that little green sheet in the court documents. You can see across the board, all of the legal practice went up when they became an ICWA court. So making all the different findings, all the requirements went up, but some went up more than others, and those are our significant findings. So we were excited to see practice changes in the right direction for the letter of the law. We also looked at how the tribe is present. And for this study, we looked at tribal representatives and tribal attorneys at hearings. One of the things we learned in our last round of work was that the tribe being present at the first hearing on the case is a good predictor of better outcomes for children and families. And you see from this top graph, there was a big increase in a tribal representative being present at the first hearing on the case. Tribal attorney was a slight increase, but we see a change for those. And then we look across the life of the case. And for us, when I say life of the case, what I really mean is the first year through the first permanency hearing. We didn't look at all the hearings if they went on for extended times. We focused on those first hearings in the first 12 months of the case up through whenever the first permanency was held, and looked at who was present. And you can see on the bottom, all of these are significant differences in how often they're present. And the tribal attorney was present in 78% of hearings post implementation of an ICWA court. So we're getting tribal participants there. We tried to look at tribal involvement in terms of case planning, assessments, placement recommendations, or placement, doing the home studies for placements, other ways the tribe might be involved. That data we learned the hard way. It's really hard to find. We could tell if an agency caseworker put in the report how the tribe was involved, we could tell they were involved. Otherwise, we couldn't determine how well the tribe was invited or participated or became involved with the family throughout the life of the case. So we relied heavily on that. So we had a lot of we can't tell data. And so that played into whether we could say anything really well about that. Mostly what we can say is the tribe was involved here. In terms of our outcomes, in post-ICWA court, we saw more outcomes with relatives. So that could be guardianship, it could be legal permanency, allocation of parental responsibility, excuse me, whatever your language is. But we saw more outcomes with relatives, similar outcomes with parents in terms of reunifications, more outcomes with relatives, and fewer terminations of parental rights in this site. And then we did some predictive modeling, which I will not go into the mechanics of that, but we're looking at the relationship between factors. We combined all those ICWA legal requirements into one percentage. So in what percentage of the things that they were supposed to do happened on a case for the legal requirements. And we found that the more of those they did on the case, the more likely the child was to end up with a parent or relative at permanency in this site. So that letter of the law, when those increased, we had more outcomes that were a parent or relative for this site. Our findings in the second site looked a little different. We learned some new stuff. For this one, we looked at data over time. We had 4 years of data where we looked at the files. All these were closed cases. And we had, when we talked to the site, there had been 2 different things that they implemented in 2019 and in 2020. So we were kind of looking at those trends of how that might change practice. We took all those legal findings, as I just said, and made a construct combined. You can see that they did the majority of these things in their cases. The lowest was 76% in 2020. So they were doing the ICWA legal findings in the majority of these cases. It didn't really change much over time. 2018 was like a big year, but the rest are around 77, 76% in terms of what we found in the documents and the files. to say that they had participated. So we didn't see a big difference then. However, we did see a big difference in tribal presence across those years. So they had increased some of their things meant to try to enhance their court, and we saw tribal presence across the first year of the case go up from 70%, consistently rising to in 2021. The cases that we reviewed, there was a tribal representative present in 90% of the hearings on the case. And this was a significant increase over time. So those changes that they were making as they evolved as an ICWA court, they were already doing well at the letter of the law, but increasing that tribal representation at the hearings. So we found a positive impact there. And we looked at outcomes for those. The outcomes for the second site were a little different. We can't compare pre and post to say they had more of this or more of that. But what we did see is when we had higher involvement of the tribe, there was more likely to be permanency outcome with a relative, not a parent, but with a relative on these cases. And when the tribe was present at the first hearing on the case, that was also related to a higher likelihood of permanency with a relative. And permanency with a relative, like I said, could be defined differently based on the site's guardianship, legal permanency, allocation of parental responsibility. It depended on the language and the things that the site used. You guys know across the country, your practice varies quite widely in what this might look like in the outcome. But this is something we found in our early work as well, that the presence of the tribe at the first hearing seems to really make a difference. So we replicated that finding with this site in particular, that it makes a difference. And that goes back to all the research that we have on front loading and how important it is to get things going early in the case for these. So for this site, we had some positive findings. Overall, I will tell you, there's a couple limitations to our study, and that is measuring tribal involvement in the case is challenging if we don't have consistency between the caseworkers and how that gets reported to the court, and we're not talking directly with the tribe on each of these cases to better understand. We didn't get perspectives from parents or youth, and that is a place where we think we're definitely going to see a big difference. We miss a lot of the nuances of what's happening in court when you just look at the files. And it doesn't always tell us why there are differences, just that there are. But the big key takeaways that I pulled from this, and we're going to have a nice conversation around other takeaways and how this data might be useful. But what we see consistently is that so far in all our research, the ICWA courts show enhanced ICWA legal practice for sure. At a minimum, making sure the T's are crossed and the I's are dotted. That ICWA courts do have high rates of tribal representatives present in both sites. The numbers increased over time, but also were very high in terms of how often they were present at the first hearing on the case, which requires really early notice, as well as across the life of the case, which we considered a positive. And we did see statistically significant relationships between ICWA practice, both letter and spirit of the law, so those legal findings, and tribal participation and better outcomes for children and families across both of the data sets. So for me, I'm seeing that as a positive. This is something that can help us contribute to the growing evidence around the effectiveness of ICWA courts. They're not 100% across the board doing everything, but we see consistently trends, improvements in practice, improvements in involving the tribe, improvements in outcomes for children and families, where we have less TPRs, more parent and more relative placements across both sites.
Wow, thank you so much. And thank you very much. I think Dr. Summers, you're probably the best researcher I've ever heard explain data and explain methodology and explain outcomes and make me understand it. So I'm a lawyer that doesn't really know numbers that well. So thank you so much for that. We're going to bring on our panelists. And so the first question that we're going to talk about actually is just your general reflections from that. And Dr. Summers, you're part of our panel as well. So, so let's do introductions. So it's a two-part question. One, introduce yourself, tell us where you're coming from and what you do and why this work's important to you. And then the second question, what's some general reflections that you have from that presentation and kind of learning about those sites? And so we'll go with you, Judge Bostwick, first.
Hello, everybody. It's really great to be here. I'm Janet Bostwick, and I'm an ICWA Court judge in Tucson. This is Pima County Juvenile Court. I'm really honored to be here and also to serve on this bench. We are Site 1, and data that Dr. Summers just went over. We're really grateful to NCJ, FCJ for all the work they do in this area, and to Casey Family Programs. Incredible support for children and families across the board, and also crucial to ICWA Court work. So thank you. So reflection on the data, it was just so good to recognize that process matters, because that is a big part of, and at least in our view here, is trying to make sure that standards are followed, honored. The letter and spirit of ICWA are present in the courtroom at all the hearings. We do a lot of work on facilitating processes, forms, special blocks for ICWA cases, so the tribes know when their hearings will be, in advance, and that kind of thing. So I'm happy to explain to anybody that's starting an ICWA court, and ICWA courts collaborate, all talk across the board. So anyway, that was good to know. It just seems like if you can work together to follow the law and implement best practices involving the tribe, we can give people the best chance of staying together and staying in their community and culture. And that may go across the board beyond ICWA cases, but we're learning a whole lot that applies. Now, data, you wait for your data results and you're a little nervous, honestly. You're thinking, we're doing these things and are they working? But it's just as important to find out if the data is saying something's not right. So transparency there is crucial. And that helps us work to improve and give some ways to strive to do better. One general feedback on data that I had is, because we talked a lot about the tribal involvement, how crucial that is, how it's gone up. A great idea, I believe it was Judge Quigley here had, that we worked together on, Kathleen Quigley, who really started ICWA Court here. Crucial part of it, anyway, was to make sure tribal caseworkers, if they don't have an attorney and they're not intervened with counsel, the tribe, they still get involved. So we worked with our clerk's office so that the tribal caseworker is on our court calendar, gets recognized and heard in every hearing, and they get copies. They get treated as a party, even though they're not represented by counsel and they're an entity. So normally that doesn't happen. But, someone's self-represented, they can't self-represent an agency or a tribe or a sovereign nation or anything other than themselves. But we made it happen here. So they're informed and they're involved, because that is part and parcel of ICWA, is to involve the tribe. DCS involved the tribe. And I think the data results are better because we are recognizing and including representatives, even if the tribe doesn't have an attorney or doesn't intervene. Just the other thing I was thinking of as we were going through the data, and I wanted to say in a general way, is that juvenile courts keep data on time standards and outcomes, and that's a requirement. It's been going on for a long time. So we've always had courts, our court, other courts, looking at how long do we take to get to the permanency hearings that we're supposed to have, for example, within 180 days if the child's under 3 at removal, and 12 months if the child is they're over at removal. And how long are we taking to get to the outcome? A lot of time standard things, which are very important. But we've given more thought, sort of a depth of thought, when we're looking at ICWA cases. They take longer. So in telling the data, they take longer to resolve. And considering what that means. So we just take that in context. We know sometimes it takes longer because notice has to go out. It takes longer because you need a qualified expert witness to come in before you can adjudicate and move forward, even in an early part of a case. It takes longer to make sure that we are accommodating the presence of relatives sometimes and giving time for the placements to be found in culture. So things can take longer. Then that's a general observation about the data we've seen. And we just take that as part of what we're seeing going on and thinking about where that, how that cuts. But we also know we have very ICWA relevant data that's not in the general data that is generally collected by courts. So if you're in ICWA Court or you want to start gathering this data, our data people are really great resources for doing that. They are amazing, in my opinion. I don't know how to do regression analysis, and look at all this, and Dr. Summers impresses me. Amazing work. And that can be focused on what's ICWA relevant. So in other words, we're really starting to call out, well, for example, as Dr. Summers was saying, not just did this end in a guardianship, reunification, or adoption, severance, but where was that? Was that in culture? Was it with a relative, as we're talking about? Where did this child end up? So we're tracking the placements. We're tracking how early we have them and what they are. We're really looking forward to continuing to gather data and continuing to look at what it means. And if there's a recipe here for it in the ICWA kitchen, that is going to help us improve results in ICWA cases and across the board. So those are some lengthy but general observations on the data, with a whole lot of gratitude that Casey has come in and examined it and helped us look pre and post, and all the support we get from the council and from the experts and wonderful collaborators at Casey. It's all about collaboration. It really is about working together. So happy to be here and be part of that.
Thank you, Judge Bosco. Appreciate that. And it's nice to have you on here. Shana, let's go to you next.
Dosha, everybody. Hello in Hidatsa. My name is Shana King, and I am a citizen of Fort Berthold Indian Reservation. I have been working at the ICWA Law Center for about 13 years now as a parent mentor. I was somebody who aged out of foster care, and then I had my children placed in foster care and successfully reunified with them. And I'm not a data person. I hate data, but I know it's a necessary evil. I don't like it. But some of the things that like kind of got me excited is that there's 24 ICWA courts right now. So that's exciting. I wish that there were more. And I think one of the crucial points, I'm just going to piggy off of Judge Bostwick, is that the tribe is at the table. And for me, working with families, I'm very fortunate to work in an ICWA court. And anytime one of my cases that I am on goes non-ICWA, we're all disappointed, because what a family gets in with an ICWA case is so much superior to if it was non-ICWA. But one of the things that I think that is important is that the tribe is at the table and they have a say. I know personally for me, when my case was opened, from growing up and aging out of foster care and then becoming adult in foster care, I didn't have family support. So the first support I ever really received as a parent was from my tribe within my ICWA case. And that made a big, huge difference for me, because now that tied in my connection to my actual blood family, which was amazing. But now that I work with families that have an ICWA case now, not just being at the table to have a say, but that relationship that they build with their tribe is beautiful. And a lot of times tribes have resources that the courts don't, that we don't see. They have like beautiful, here in Minnesota, Red Lake has a beautiful visitation space. And I mean, I could go into like how visitation is kind of a weird concept, because we want to spend time with our kids, but who really sits in a room and just stares at your child, right? And so Red Lake has really done things to alleviate that. There's just so many resources. And then they have like ceremonies that their families can participate in. A lot of our community agencies, our tribal agencies, have drum making class and ribbon skirt making, which is really crucial for a family to heal, because we need to have our cultural traditions. And I don't think that is carried across in data, but those are things that are really important for families.
So much there, actually, and I really like, and I can just kind of speak from my lived experience. I've been able to be fortunate to work with a lot of the ICWA courts. And it seems like at the very beginning, like the process of like listening to tribes, listening to like sometimes the communication between the state court and the tribes, and what that experience is like for a tribe to intervene either virtually or actually in person. I think a lot of barriers get knocked down, kind of like what you're talking about, Judge Bostwick. And so just being able to eliminate some of the tracking errors of it, of how tribes could show up. And and be dynamic at solving those problems. So, and tribal participation and connection is, I think, the key to that. Dr. Summers, I'm going to give you some space. You did a little bit of an introduction of who you are, but was there anything shocking to the data that this data set, or your general reflections when you started kind of putting everything together? And I know you've done a lot more data research studies, and I might regret saying this, but I do have the whole, if you want to go to the bottom of the ocean of ICWA courts and data, if you send me an email, I have an email prepared that I can pretty much hit send. And it has a lot of the research that Dr. Summers has done in other areas as well. So, but I do have it, almost all the data in just one email. So if you're interested in that, send me an email, I'll get that to you. But Dr. Summers, any reflections or shockers or?
I would say I wasn't too surprised with the data. I am always excited when I get to the analysis phase and we see a difference, because it's so disheartening to talk to sites and be like, we looked at your data and you're not doing anything different in practice. And it just is very discouraging. And I know even those findings are useful to the sites to help them improve. But for me, it's always a little disheartening. So super excited that we had findings and they were positive. I do think it's really interesting, some of the variations that we see in sites. And I think for me, it opens up the exploration of what are the things that make a difference and why does that vary by site. In both sites, we see the changes and high levels of the letter of the law. But the letter of the law really mattered more in one site as a predictor for outcomes than the other. And the tribal presence mattered more in one site. In our prior research, where we looked at 5 sites, we saw that tribal presence and the letter of the law stuff both being significant predictors of outcomes for children and families. And so I always find it interesting when we get in and we're like, one site, this is a predictor, another site, this is a predictor. So what does that mean? It opens up a lot of exploration of what are the other things that are happening at the site that also might be predicting these outcomes. And that is one of the things that we always learn. For this round, we really did try to look more at like, is the child involved in maintaining cultural connections in some way? We really tried to look at how the tribe is involved throughout the life of the case. The data are just not there from the files that we need to be able to report on that, which just means in our next waves of doing this work, we need to think of more creative ways to try to gather this information going forward, because we have heard from a lot of tribes who have been doing this work saying that's not, the time to permanency is not what matters to us. It's maintaining these connections. And so we're trying to reflect that. But I think going forward, it's going to be really important to think about how we can capture that and really look at it to see how we can encourage that within ICWA courts and other courts in the country.
Thank you. The next question, and like I said, if you guys have questions, if you're listening to this and you're like, I have a dying question here, put it in the chat and maybe put question next to it just so I could see it and ask it. But the next question, I've had this conversation with you before, Shana, and you've kind of talked perfectly about this, but I kind of want to flesh it out a little bit more about like the definition of success in this practice, and I think Judge Bostwick, he kind of touched on it a little bit as well, as like court systems have data tracking systems that kind of show you, like, are you making these findings? Are you having these types of hearings along this timeline, So you could be successful and terminate everybody's rights that ever come before you because you're hitting the timelines correctly, but is that success? And what are other ways that we measure success? And I kind of reflect, one of my reflections about this is like I think of those ICWA concentric circles. I always think that's the target sometimes for us, is like and it's with it explicit in the law, we're active efforts to keep kids with families. If that's not safely possible, we're looking to kin and relatives, and all that happens with the community and culture. So maybe the definition of success is connectedness. I don't know. I'm throwing that out there, but I know, Shana, you could talk more articulately about this than I am. So what do you think about when you think about success, and what are other data points or factors that you look at as far as success?
I don't know if I'll be more articulate, but I could definitely speak towards it. I think when I first started working as a parent mentor, which is peer-to-peer support for families here at the Law Center, I used to think reunification meant success. And that has definitely changed for me. I think at the Law Center, we're very unique because we believe that everybody has their own story and it deserves to be heard and it deserves to be spoken. And not everybody wants to reunify or is able to reunify, especially because we still, even though it's ICWA case, we're still in the colonized system. So we still have constraints like timelines and out of home placement. But I think, I recently had a dad who's disabled and mom, he fought for his children so hard and custody was with mom and mom just wasn't doing well. She wasn't able to complete her case plan by the timelines that we are subject to. And dad wasn't able to care for his kids, but he wanted his mom to. And now the kids are back on the tribe with mom and he gets to see them all the time. And then, or with his mom, and then he gets to visit them all the time, but mom gets to visit them as well. And I think that's really a huge success story. And not only that, but like one of the kids wasn't his, he was a stepdad. And that child got to stay with him because that's what she preferred as well. And I think that's just like a story that we don't talk about often, about like the desires of the parents if they're not ready to or they, by the timeline that's set up for them, if they're not ready to have their kids home with them, to have them in a placement that they prefer is ideal. And that that the children and the parents can continue building their relationship so that they continue to do the traditional things they want to. And then we've had cases where I feel like I've worked with many families who have never not been able to meet that timeline data, and there was going to be a TLC happening. And to make sure that that family knows where their children is going and that they build a relationship wherever their kids are so that they can have a relationship, a continued relationship with their children. I rarely have ever seen, I'm sure the attorneys here have, because I don't get to come across all our cases, but rarely do I ever see in an ICWA case a family completely cut off from their parents. I think that's really crucial to know too, that like within ICWA cases, we try to keep them within their tribe, within the with a relative. But we also make sure that that relationship stays in place between the parents. And sometimes those outcomes are not counted in data, but because it's not necessarily reunification. But in our hearts, I can sleep at night because I know that parent is going to have a relationship with their child and that they can continue to do the things that are important within their family.
Thank you. I love that. Relationships is a measurement of success. And I know Judge Bostwick, same question to you, just about other ways that you measure success in your work. And I know maybe I'm skipping ahead here, maybe you're going to talk about this, but I know you have gone on a tribal visit before and built relationships on a trip to Navajo Nation. And so has that been rewarding? Not, hopefully that's not too much of a leading question, but what
No,
are major relationships?
it's definitely one of the most amazing opportunities in ICWA Court is to get to work with the tribes and learn about the tribes and learn about culture and history and just be a real humble learner, because you find out really quickly what you don't know, and you don't know until you learn and you're told. So when tribes are willing to open up and share and tell you about and show you the ways of their life and their history and traditions, it's it is an honor and a privilege, and it's something that is not captured in data, but you can spread and across your ICWA court, across the ICWA court community into other courts to just encourage learning about the tribes, each tribe being different and individual. Our trip to Window Rock with also Maricopa County, the Phoenix area ICWA court was it was more than educational, as in many things ICWA. It was really moving, as it has been when we visited with the Tana Out of Nation here, visited tribal courts for Pasco Yaqui tribe and the nation, the Tana Out of Nation here, our primary local tribes in Pima County, and gone out to their museums and just talk with them about how life looks in the tribe and their culture, hear about the cultural events, get the kiddos to the cultural events, making sure in the courtroom people are finding out about that. I just want to also mention, though it's not necessarily captured in data too, that this is all part of really huge teamwork, stuff that happens outside the courtroom. So a lot of what we find happening that's very meaningful, tween hearings, is that we have DCS and the tribal social workers and parents, attorneys, and minors attorneys communicating frequently. We have teams in ICWA Court. Again, every juvenile court has ICWA cases. Every juvenile court needs to ask the questions. It's just kind of the point here to find out if ICWA applies and move on and follow the letter and spirit. But and the way we structure ICWA Court when we're focusing highly on those priorities is to set up teams. So our AGs, the attorney generals are in, they know ICWA. The minors council, they know ICWA. The parents attorneys too, and they work closely with the tribes. So they are educated. They raise their hands to do the extra work and have the extra learning to be in ICWA Court. And I know from talking with them that they get more communication. They build more trust. Parents can see too that they have a process here that is pretty inclusive. And if they're not comfortable with DCS, they start being comfortable or with the tribal social worker as another voice in the courtroom along with their lawyers. So there's a lot of teamwork that maybe isn't in the data except for tribal presence, which is crucial, but it's across the board. And one more thing, if you don't mind my running on a little bit, but that part of teamwork, it also is between ICWA courts. Like I say, if you don't mind my saying so, Megan Gonzalez is here, Albuquerque from Burleigh County. We have informally gotten together and worked on our processes together, which is great. Pierce County, you might be the most recent ICWA court. I remember we had a meeting together, groups of us, to talk about getting that kicked off. It's exciting that you're doing it. And the way, and Casey in particular gets those collaboratives together and gets us all communicating. It's the benefit of working together that comes through time after time. And I believe we're seeing it affecting results too. So thank you for everybody that partners. Keep reaching out to each other is the way I look at ICWA Courts. We have a lot to learn, and together it's makes all the difference to share information and have meetings like this.
Thank you.
Definitely.
Appreciate that. Appreciate you giving shouts. There's a few ICWA courts on here, so it's good to see Albuquerque Court on here and Judge Begay I see in the chat as well. So this is great. Same question to you, Dr. Summers. I'm going to hook in Ken Daly's question that he put in here as well, because I know we had thoughts about this when you're developing the tool to assess connectedness, like how do you measure connectedness? And so if that's a success measurement, and I know you're skilled at measuring everything, so almost everything. And I appreciate you being so candid about some of the weaknesses in this study. And so not being able to interview parents or children being one of them. But could you talk to us a little bit about maybe the tool that you developed, and then how would we measure connectedness?
Sure. So in the file review, we attempted to measure it with just a basic yes or no. Do we see any evidence of this? And we did see evidence of the youth maintaining connections to the tribe by the agency reporting on how they were connecting the youth, or that they're making sure that they're going to ceremony, or that they had built in this opportunity to attend these different events, and they talked about it. And so they're talking about the things that they're trying to do as part of their active efforts with the youth to maintain these connections. And so that's what we were looking for. Did they attempt that? Some of them just say they talked to the youth about that. Is there any evidence of that happening? But as I said, that's a really poor measure. It's like trying to see if we can find it somewhere in there, because it's so inconsistent, the level of detail that we get from the caseworkers coming back to the court. And we don't know how often that's happening, that's not being classified in there in some way. I would say the best way to measure it would be to ask the youth. And I know California, the acronym is eluding me, the California Coalition They have a survey for youth. It's not in place right now because that also requires IRB and lots of extra steps if you're going to talk to youth. But they do have a survey that was developed to talk to the youth about their connections. What was their connection? And you give it to them at multiple points in the case and ask because they may not have had a connection to the tribe prior to this. And we want to see if that builds over time or if they start with a connection and they lose it over time. But really asking the youth about their connectedness or their feelings of connectedness, the things that they're involved in, the things that they're interested in related to maintaining those connections, and it spells some of that out. So I think for me, the best way to measure it is to talk to the youth and families to find out how they would define it and build up a tool around that. But it's going to require asking, and we know that is very resource intensive and that we don't get terribly good data when we try to survey folks just generally in the field. So, but that would be my recommendation is to talk to the children and families and have them help define it in a way that's most meaningful. You can always build a survey tool based on how people are describing it themselves and allow them to do it, or focus group questions or things like that to get it directly from the people who are most impacted by this work.
You got a correction on what the California organization's called in the chat, but it's the California Tribal Families Coalition from
Coalition, thank you. Yes, I was like, it's in here somewhere. I know it is, brain, but getting it out was a struggle. So thank you.
But yeah, and if you Google that, yeah, you'll find some of their great work from Kimberly and Sarah, both from that organization. They're fantastic. Next question, and this is kind of like maybe a speed question, and those that kind of know me and been around me, you're going to hear this question and roll your eyes, so I apologize for that. But it's a question about rosebud thorn, and so it's just kind of this idea about an appreciative inquiry of what you're observing in your practice. And so, of course, Judge Bostwick and Shana, you see a lot of ICWA cases. You're so experienced in this work. And so when I asked the question of rosebud thorn, in your practice, like what is something that you've seen that blossomed is in a beautiful rose and you're like, yes, we're doing great things there and it's blossomed and we're continuing and consistently doing that for Indian families. The bud, something that you're excited about, maybe it's on the horizon, and then the thorn. What's the challenge? What's the pain in your behind, you know, that you wish, and there's gonna be a part 2 of this question, but we'll go to you first, Shana.
Okay, so I think that my rose is that knowledge is power. And not just knowledge about ICWA where we're not arguing about what active efforts is and if this qualifies for active efforts. But it's knowing the community. So if you have an ICWA court, you know all the culturally appropriate programming that goes into helping a family. And a lot of in Minnesota, we have 11 different tribes here, and we have a wonderful community and we have such wonderful programming. So like I said earlier, we have programs that help to make ribbon skirts, for example. So if a judge knows that this family is participating in this program and is part of the case plan, you know, gifts or orders a sewing machine, and that mom can make regalia for their child when they're in out-of-home placement, how beautiful is that, right? And then, like I said earlier, like the success is not always reunification, but if that mom can continue to make that regalia for that child throughout their life, like what a beautiful thing to have happen, and what a connection that, you know, has been lost that we can build back up. I also think that what is it? The rose, the bud, and the thorn. Okay, so my bud would be that I love seeing people learn about ICWA and come to the understanding of why it's so important. Because our history is kind of an elective in this country. So having people understand the importance of it makes them makes them work harder towards keeping a family together and makes them think outside of the box. For my case plan, one of my visitations was at powwow, right? So that kept our culture intact, let me spend wonderful time with my son, which I didn't have to like stare at him across the room with toys we didn't even enjoy. And then the foster family asked if they could come and stay. and it was a non-Indigenous foster home. And they got to learn about the culture too. And then they got to be able to play songs for my son. And my son was disabled, but one of the things that he was able to do was press a button to make powwow music go. And he loved that. And he wouldn't do that for other things. And I really think that is something that came along because of our case plan. So we get to think outside of the box. So I love that piece of things. I love seeing the attorneys that I work with really fight for things that really wouldn't be normally on a case plan, but it would qualify as an active effort. And then my thorn is that we are still stuck in a colonized system. So I hate the timelines. I hate that we don't recognize family structure. Because my cousins are my sisters and brothers, and that's not shown in the case plan, so we don't count that in for visitation. And I think that's just an injustice to Indigenous people, because our family structure is very different. And then we come into a space where that's not recognized. It's really hard, and I think that's a trauma that we don't really talk about, that how we cut those significant relationships out of our life because we don't get those visitations or things like that. So that would be my rose, bud, and thorn.
Thank you so much. There's so much beautiful things there. And similarly, back in the day when I used to do the work, I felt that was one of the struggles, is that this will is broken. And so the system is broken. And you could be a great advocate. You could be the straightest spoke in the whole will, but the will's broken. And so thanks for pointing that out, and the need to follow on advocacy to fix the will. Judge Bostwick, seen a lot of ICWA cases. What's your rosebud thorn?
Rose, I have to second the importance of relationships and trust building. It is so crucial, as we've said, to ICWA Courts. It's a pleasure personally, but also it makes a difference in how our cases go and spreading the word and spreading education. So it's all that togetherness and collaboration with a lot of other people that supports that gold standard work, the partnership. So we're starting to see the results. Part of that collaboration now is with Maricopa County with us, and I'm so glad about it. They're really well organized and they're doing an amazing job, and I love working with them. Budwise, I just have to say our recent data, since it's talking about data here, there's a lot of qualitative things that let me know that things are progressing, but quantitatively, for the first time, our reunification rate for ICWA cases is above the average for the whole court, and above the average and above the number for non-ICWA cases. And I know this changes and waxes and wanes, and it will, but I mean, I know there was some cheering in back rooms around ICWA court attorneys, and our place here, we were like, spoiler alert, am I reading that right? So that is a beautiful bud. Then the thorn, well, you know that disproportionality persists, right? It's been around, there's been a lot of efforts, but we still have a higher rate of Native children in care here and everywhere, really, than should be proportional. It's disparate, it's overrepresentation, and we have to keep working for all children and battling that disproportionality. I do want to mention in that regard that we had a speaker at the Pasquayaki ICWA conference last year. It's coming up in August 12th to 15th. If you want to register, Pasquayaki Tribe, it's an incredible conference. But what I want to say is there was a doctor last year that testified about data, medical data, and about the healing effect of tribal connections on Native children, even if they hadn't really been part of it. They're finding a home, and it had an actual medically documented healing effect. So I just want to put it out that when the collaboration includes services for children that are cultural and parents that are cultural, it has a positive effect anecdotally, and we think data-wise.
Awesome. Thank you, Judge Bostwick. Appreciate that. Dr. Summers, and what I realized before we even started this, I apologize, because originally I told my panels that we're going 60 minutes, but I saw this was advertised for 75 minutes. And so I promise you we won't go over. And if you do need to excuse yourself and it's almost the top of the hour, you're excused if you need to jump off and go to another meeting. But well, I think I have one more question for you, so we'll finish that question. I have a question for the audience as well, but Dr. Summers, rosebud thorn, and some of the research that you've seen in the ICWA practice.
Sure. I will make it quick. I'm going to start with the thorn. I will say getting the data is always a big challenge for a lot of reasons. Getting the buy-in from the site, getting access, having resources to do something meaningful to be able to look at this. And so I think sites really want to have some data and some information to reflect on, but it's harder to get in the courts, the level of data that they need to be able to do that. But the thing that I found, like the bud that's really hopeful, is that courts seem to be really using the information when they get it, that data, to look at their practice and try to enhance and see how they can use it in continuous quality improvement, which I really appreciate. And for the rows, I got to learn a lot about the sites and what they were doing. And I was so impressed with all the problem solving and flexibility I saw within the ICWA courts. And that's something that doesn't get measured within the files and the way that we're looking at it. And I think that is one of the big keys, is how to use that information effectively to be able to do something different with families, to help them in a way that might be a little more outside the box than we might have in our other court hearings.
Thank you so much. That's awesome. And so the second part of this appreciative inquiry is, so you brought up everybody brought up some thorns, and then you on the audience. And what I love about Zoom meeting rather than webinar, as I love seeing the chat, and I love the interaction between each other and people corresponding to each other in the chat. So I love that so much. I love seeing all of our faces and our names. And so that's wonderful too. So, I'm asking everybody on here to participate in this as well. And so if you had a magic wand, and so this is to you, Shana, right now. So you brought up the thorn of the colonial system and how it's fundamentally framed to not serve the humanity of human beings. If you had a magic wand, what would you do to change that, or change some of the other things that are connected to Indian families? And so what are some of the things that you would address? And that question goes for everybody. If you want to put your answer to your magic wand approach and tips for people in the chat. So, Shana.
I think if I had a magic wand, oh my goodness, this is a question I get asked a lot, and it's like there's so many things I would want to change, and I do not feel like our system is broken. I think it's firing on all pistons and doing exactly what it's designed to do, and that is tear apart Black and brown families. So I would probably do away with this system, and for Indian families, I would have tribes be more in control of what's happening. And I would want to go back to our traditional ways. I would want to see ceremonies as a part of our case plan. I would want to see more culture in that. So I guess I would take the government out of it, or the United States government, and add in our tribal government to govern over our people. And I would have spaces where children didn't have to be removed unless it was absolutely necessary. And that we would have spaces, not just foster a child, foster a family, maybe, or, go back to our ways where our aunties and uncles and grandmas and grandpas are helping. So that's what I would do.
Thank you so much. Judge Bostwick, your magic wand.
Magic wand. Well, I'm really agreeing with what Shana's saying now and earlier about recognizing that a tribal family is not the same thing as family, and relatives are maybe defined in your statutes for juvenile court cases, right? That I would have a magic wand that recognizes all the people that make up a family in this particular tribe, and it may be grandma and grandpa raising the child, the aunties. So when we try to, in a courtroom, when we have the tribal presence, recognize the actual relationship in the tribal culture. It may not be actually related, but it may be a traditional, cultural, or recognized as an aunt. Well, the magic wand to help recognize all those things and magically get early placement in culture, magically. That would make all the difference. So early placement with a relative, significant relationship, someone within that tribal family, that would be a beautiful change.
Awesome, thank you. I know like a lot of the research too, and Dr. Summers talked a lot about it, but like ICWA compliance, if you're gonna get ICWA right, seems like it's that front end of ICWA. Even
Front
better
end.
outcomes for families, it's that front end, and so that magic wand is great, thank you. Dr. Summers?
This is really tough for me. I won't talk to my challenge because my challenge would be easy with the wand. Do we just have data on all the things that we need to have data on to be able to make informed decisions, which I know would require some magic for us to get. But I would say with the ICWA cases, and I think this is true even beyond ICWA cases, we would spend, if I could wave the wand, there'd be more individualized attention to the families and the cases, especially early on. That initial like engagement and understanding what's happening and getting folks involved, and just taking that time to look at cases like they're not numbers, like they're people, and getting them involved at the very beginning of a case is so important. From all the research, I think it would just give the courts more time to be able to do that, and the capacity and understanding of how to do that in a meaningful way.
Thank you so much, and I appreciate everybody that's great. I appreciate everybody putting those in the chat as well. There's some really great tips there. We're going to save the chat, and I appreciate everybody having some time today. I'll tell you one of the things that Casey, what we're trying to do with our magic wand is for ICWA Courts, and we've done it for a couple of jurisdictions, including Judge Bostwick, who was just there actually, is teaching attorneys, and I know this sounds funny when we get there, teaching attorneys how to assess safety. Sounds like they're trying to teach pigeons to play ping pong or something like that. We're trying to teach attorneys how to assess safety and make safety arguments. And so the ADA produced the safety guide a few years back, and so we're trying to bring that framework to each of the 24 ICWA courts. We've been at 6 so far, so we're moving, we're chugging along. And then the other thing is, how do we bring compassion into this work? And I do think that's, if I had a magic wand, I know all of us, everyone on here has had heartbreak. Every one of us on here has had trauma in their life. And so how do we show self-compassion for those things in our lives? And in turn, how do we spread compassion? And so we're trying to teach everybody that works in ICWA courts some of the principles of self-compassion. And so that's what we're trying to do with the magic wand that we have right now. So I appreciate everybody that jumps on here. I know like a lot of you and know your work and you're amazing advocates, and it's really an all-star team that's on this, the 147 people that I think we had at one point on this call. So thank you so much. And I'll stay on for a little bit and I'll be reading your guys' chat. So thank you so much, and you guys have a good day.
Everybody so much.
Thank you.
If I may, there was something in the chat from
Yeah.
Gary about his nephew